testify as a witness. Now, there is, for your consideration in this case, or there may be oral statements that you've heard allegedly made by the defendant, and you know there was testimony about his signature on a document. It's your function to determine whether or not the statement was actually made by the defendant, and if made, whether the statement or any portion of it is credible. In considering whether or not an oral statement was actually made by the defendant, and if made, whether it is credible, you should receive, weigh, and consider this evidence with caution, based on the generally recognized risk of misunderstanding by the hearer, or the ability of the hearer to recall accurately the words used by the defendant. The specific words used and the ability to remember them are important to the correct understanding of any oral communication, because the presence or absence or change of a single word may substantially change the true meaning of even the shortest sentence. You should therefore receive, weigh, and consider such evidence with caution. In considering whether or not the statement is credible, you should take into consideration the circumstances and facts as to how the statement was made, as well as all other evidence in this case relating to this issue. If, after consideration of all these factors, you determine that the statement was not actually made or that the statement is not credible, then you must disregard the statement completely. If you find that the statement was made and that part or all of the statement is credible, you may give what weight you think appropriate to that portion of the statement you find to be truthful and credible. Now, as you know, ladies and gentlemen, Mr. Albutt is charged in one count of an indictment, and that charge reads as follows: that on or about August 7, 1999, in the borough of Butler, that Simo Albutt did unlawfully and knowingly or purposely possess a controlled dangerous substance, namely cocaine, as contrary to our state laws. Now, in that regard, the pertinent part of our statutes on which this indictment charge is based reads as follows: it is unlawful for any person, knowingly or purposely, to obtain or to possess, actually or constructively, a controlled dangerous substance. The various kinds of controlled dangerous substances are defined in another part of our statutory laws. Cocaine is a controlled dangerous substance prohibited by statute. The statute, read together with the indictment, identifies the elements which the state must prove beyond a reasonable doubt to establish the guilt of the defendant on the indictment. They are as follows. Number one, that S4A in evidence is cocaine. Number two, that the defendant possessed or obtained S4A in evidence. And number three, that the defendant acted knowingly or purposely in possessing or obtaining S4A in evidence. In regard to the second element, obtain means to acquire, to get, to procure. Possession means as follows. The word possess, as used in criminal statutes, signifies a knowing, intentional control of a designated thing accompanied by a knowledge of its character. Thus, the person must know or be aware that he possesses the item, in this case, cocaine, and he must know what it is that he possesses or controls. A person may possess cocaine even though it was not physically on his person at the time of the arrest, if he had in fact, at some time prior to his arrest, had control and dominion over it. When we speak of possession, we mean a conscious, knowing possession. The law recognizes two kinds of possession. They are actual possession and constructive possession. A person is in actual possession of a particular article or thing when he knows what it is, that is, he has a knowledge of its character, and knowingly has it on his person at a given time. I have a pen, I know what it is, I'm holding it, I'm possessing it. Actual possession. The law recognizes that possession may be constructive instead of actual. A person who, with knowledge of its character, knowingly has direct physical control over a thing at a given time is in actual possession of it. I'm holding the pen. Constructive possession means possession in which the person does not physically have the property, but though not physically on one's person, he is aware of the presence of the property and is able to exercise intentional control or dominion over it. A person, although not in actual possession, has knowledge of its character, knowingly has both the power and intention at a given time to exercise control over a thing, either directly or through another person or persons, is then in constructive possession of it. When I'm holding the pen, I have actual possession of it. I know its character, I'm holding it. If I put the pen over here, it's not physically on me, I'm not holding it, but if I have a knowledge of its character and I'm able to intentionally exercise control over it, either directly or through another person, and I know what it is, then I'm in constructive possession of it. In regard to the third element, the state must prove, as I have stated, that the defendant acted knowingly or purposely in obtaining or possessing S4A. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of that nature, or that such circumstances exist, or he is aware of a high probability of their existence. A person acts knowingly with respect to a result of his conduct if he is aware that it is practically certain that his conduct will cause such a result. Knowing, with knowledge, or equivalent terms have the same meaning. A person acts purposely with respect to the nature of his conduct or a result thereof if it is his conscious object to engage in conduct of that nature or to cause such a result. A person acts purposely with respect to attendant circumstances if he is aware of the existence of such circumstances or he believes or hopes that they exist. With purpose, designed, with designed, or equivalent terms have the same meaning. Remember that when we speak of knowingly and purposely, we are speaking of conditions of the mind that cannot be seen. It is not necessary for the state to prove the existence of such mental states by direct evidence, such as a statement by the defendant that he had particular knowledge or a particular purpose. Knowledge and purpose, as separate propositions of proof, do not commonly exist. they must ordinarily be discovered, as other states of mind are, from circumstantial evidence. That is, by reference to the defendant's conduct, words or acts, and all the surrounding circumstances. To reiterate then, to repeat to you, the three elements of this offense that the state must prove beyond a reasonable doubt are: 1, that S4A in evidence is cocaine; 2, that the defendant possessed or obtained S4A in evidence; and 3, that the defendant acted knowingly or purposely in possessing or obtaining S4A in evidence. If you find that the state has proven all these elements beyond a reasonable doubt, then you must return a verdict of guilty. On the other hand, if you find that the state has failed to prove all three elements beyond a reasonable doubt, then you must return a verdict of not guilty. Now, ladies and gentlemen, that concludes my instructions to you as to the principles of law regarding the offense charged in the indictment. There is nothing different in the way you as jurors consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon evidence presented to them. You are expected to use your own good common sense. Consider the evidence for only those purposes for which it has been admitted, and give it a reasonable and fair construction in light of your knowledge of how people behave. Remember, it's the quality of the evidence, not simply the number of witnesses, that control. Anything that has not been marked into evidence cannot be given to you in the jury room, even though it was marked for identification. Only those items marked in evidence can be given to you. Shortly, you will go into the jury room to begin your deliberations. Remember to apply the laws I just instructed you to the facts as you find them, for the purpose of arriving at a fair and correct verdict. The verdict must represent the considered judgment of each of you and must be unanimous as to the charge. This means all of you must agree if the defendant is guilty or not guilty on the charge. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and to change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or the effect of evidence solely because of the opinion of your fellow jurors, or for the mere purpose of reaching a verdict. Remember that you are judges of the facts. Remember, in this case, you may return a verdict on the charge of either not guilty or guilty. This is a criminal case, and therefore your verdict, whatever it is, as to the offense charge, must be unanimous. Remember that 12 of you will be chosen to deliberate in this regard. Now, to assist you in reporting a verdict, we've prepared a verdict sheet which your jury person will have in the jury room with you. It's a one-question verdict sheet as to the charge in the indictment. I'm going to hold this up for you, and the first thing it says is not evidence in the case, because obviously it's just a procedural form to report your verdict. All the charges that I've given to you in their entirety are to be considered by you as to the question presented, which is on the charge that the defendant, Simo Abdul, committed the crime of possession of cocaine. We find the defendant guilty or not guilty. And once you've reached a verdict, you'll cease your deliberations, and I'm going to go over further with you instructions now in that regard. Just bear with me for 1 minute. Can you get the file? It should be by my monitor in the case. If during your deliberations you have a question, you feel the necessity to speak to me in that regard, remember to write your question. Your foreperson will write the question on a sheet of paper, and you'll give it to the officer or to Henry, the court aide, standing outside the door. He'll in turn give it to me. I'll then go over it with the attorneys to answer your question as quickly as possible. Remember to be patient. Never tell us in a question where you stand in your deliberations in terms of your vote. If you have reached a unanimous verdict on the charge, knock on the door and let us know, and we'll bring you into court to hear your verdict. Now, we're about to select the alternates. Before I do that, did counsel wish to be heard on any clarifications?
Just briefly.
All right.
Yes. I know you did during the course of the trial, but you didn't give any instruction regarding a stipulation that they can accept it or reject it.
Oh, yes. Let me do that. Thank you for reminding me about that. Ladies and gentlemen, I was just reminded that there was a stipulation read to you during the course of the trial. And if there is no bona fide dispute between the parties as to a relevant fact, the court will permit that fact to be established by stipulation. And in that regard, however, this is a stipulation read to you as jurors. It's still your function to consider the stipulation and decide whether you will accept, reject it, consider part of it, or all of it. That's your function as the triers of fact in the matter. Okay, we'll now reduce the jury to 12. If you are chosen as the alternate, just to remain in the jury box, and I'm going to give some further instructions in that regard. And after we choose the alternates, then we'll give the instructions as to the foreperson. Okay.
Juror number 3.
Okay, Scotty.
Juror number 14.
Okay, Mr. Brown. Okay, which means, Ms. Bush, that you'll be the foreperson in this matter by reason of your seat, juror number 1, and it will be your responsibility to lead the deliberations, to tell us what the verdict is when we have the question read, and when you come out to resume your seats. The clerk will read the charge, and then you'll answer as to the charge, and we'll poll the jurors to make sure they agree with the charge. Remember that your vote as foreperson doesn't carry any greater weight than any other juror in the jury room. We're simply designating you as the foreperson for administrative reasons, to preside over the deliberations and to tell us the results. As soon as the officer is sworn, you'll be returned to the jury room. Please don't begin your deliberations until we bring in the evidence to you and give you the jury verdict sheet, okay, which we'll be able to do very shortly. So we'll swear in the officer now.
You swear in the presence of Almighty God that you will, to the utmost of your ability, keep every person sworn on the jury together in some private or convenient place, and that you will not suffer any person to speak to them nor speak to them yourself, except by order of the court, and except to ask them if they have agreed on a verdict until they have so agreed.
I will. All right. Now, as to the alternates, you're not excused as jurors. What will happen is we'll have you in a separate location while the deliberating jury is undergoing their deliberations. Please remember the alternates don't discuss the case between yourselves or with anyone else. as you may be selected in case a juror cannot continue to, as an alternate juror, and to begin as a deliberating juror. If that were to happen, then I would give further instructions to all of you as to how we would proceed in that regard. If there is a question from the jury or a verdict is reached, of course, we'll bring the alternates back in to hear the question and, of course, to hear the verdict. Okay, if there's, counsel, is there anything further? If not, I'll have you go over the evidence. We'll have the deliberating jury go in to begin their deliberations, wait for the evidence, and for the jury verdict form before you start. The two alternates will be taking you to another separate location. We'll just ask you to wait for 1 minute while Henry takes the deliberating. So the deliberating jurors can go in. Alternates, please remain seated. Now, what we're going to ask you to do is go right into the hallway. Henry will come out, take you to a separate location. Please remember not to talk about anything you want, just don't talk about the case, okay? Go right into the hallway. You can go right out this door. Henry will be right with you. We have the jury verdict form here. Do we have the evidence that's going in? Let's just make sure it doesn't include the evidence that's part of the disorderly persons.
Yes, it's only 2, 3, and 6
Are going in?
are going in.
Okay, so let's put that with the jury verdict form, and Henry can take it right in.
I just want to see the S4.
Does 2 have, let me see, is that the one that has the other thing on it? or
S2. No, that was something else.
Okay, so we don't have the drug paraphernalia. And S4A is the bags?
The
What is
only one
it?
they requested, if they requested.
Let's see, the bags are sealed and everything? Okay, well, I think we can, why don't we just tape this up, and I think we can send this in like this, okay?
Judge, I hate to say this, but in New York, I actually had jurors open it once, even though it was sealed. I mean, I can reseal it if the court prefers, but I'd really prefer not to have it go in without a court officer present. I don't know if that story is apocryphal or not, but...
Well, the thing is, they may want to see the,
Well, I suggest if that's their case, then we can always open it in the courtroom and then
see that?
pass it to them in the courtroom.
okay, we'll tell them that S4A is in evidence. If they would like to see the cocaine, they can see it.
I'll hold on to this until we hear otherwise. So 4 and 4.
Well, 4A is the actual envelope, right? 4. I mean, 4A is the cocaine,
That's
right?
correct.
Henry, we have the evidence. You can tell them that we're holding on to 4A, which is the cocaine. If they need to see that, they can request it.
Okay, so this is the form.
That's
all
the
the
form,
evidence.
that's the other evidence that goes in with them. They can start their deliberation. Tell them that 4A, the cocaine, is also in evidence. If they need to see that, we can give it to
Okay.
them.
What are they going to do for lunch?
You can ask them if they want to take lunch now or if they want to start their deliberations. Okay, all right, let me sign all this. I'm going to do some EDC matters now. So let me take care of this, and then I'll hear any further arguments with respect to the motor vehicle matters, okay?
Just come back with it.
Yeah, you can just wait here for 1 minute, because let's see if the jury wants to break for lunch or not. Okay, here's all the... Counsel have copies of the jury verdict form?
Yes, Your Honor, you gave it.
We did?
I didn't give them. Has this been more
Oh,
recorded?
you want another copy?
Let me see, I had that. Yeah, we have this.
Okay.
Court 1 or Court 2, Judge? Is it marked as an exhibit?
No, I'm gonna have one marked now.
Okay.
This will be marked as Court C1.
They're going to start deliberating
Okay.
and then think about lunch.
All right. I have the two alternates, Henry, in the hallway. If you
No, I
want-
put my question.
Oh, you did? Okay,
Already,
fine.
yeah.
Okay. All right, they're going to start deliberating, so I'll ask you to remain in the area. I'm going to do some EDC matters, okay?
Outside, though, ain't there no problem?
Yeah, you can go right outside, just remain in the area.
This is an unrelated matter. Do you recall when the Joseph Hall sentences, is that this Friday or next Friday?
Kathy would know.
Call for myself.
February 16th?
It is Joseph Hall.
Okay. So that's a while from now, right? Okay, we're having some copies made of some
Yes, Judge, we
items,
have
right?
5 matters ready.
Okay.
Your Honor, Mr. Jimenez is here, too. I've been trying to reach Ms. Daniels. She's on trial, and she's also dealing with cases.
I thought I just saw didn't I see Ms. Daniels just stick her head in?
Yeah, she doesn't have the file.
Okay.
She's asking for an adjournment.
All right, 2 weeks to the 6th, or a week? Can we do this next,
I guess we need to do it on a Monday? Is that when those cases
is
are on,
this
Judge?
a Monday case?
What's Ms.
Jimenez?
Daniels?
Let me see, Oscar Jimenez? Can I see that file? Let me just see if it's a DV matter. She's saying it's a DV matter?
Yes, sir.
Yeah, it's not charged as, it's charged as a theft, simple assault, probably underlying domestic violence. Oscar Jimenez, also known as Oscar Lopez.
Yes, Your Honor, I'll be honest, I didn't know he was on today. I am scheduled for family court all day.
Okay.
I would request
This
that
is a
we carry
Monday
this-
case, even
Yes.
though it's a theft, simple assault? Or-
This is what I'm told. I'm told it's a domestic violence case. I can't answer you. I don't have the file. I'm not familiar with it.
Yeah, there is a charge here as to AA, who I take it is an allegation with respect to simple assault on AA and theft on AA. So there might be underlying domestic violence issues. Adjourn it for a week?
That's fine, Your Honor.
Next Monday, is that when you...
Yes.
Oh, next Monday, let me just see how many there are.
Your Honor, I also indicated to counsel that I am scheduled to be at EDC tomorrow. I would be willing to do that tomorrow also.
Well, it would either be tomorrow or February 5th, actually.
Okay. Mr.
Either-
Jimenez is asking for February 5th if the court...
Okay,
please.
February 5th, all right?
Thank you.
I'll put it on Monday, February 5th.
Thank you, Your Honor.
Okay.
Thank you.
Thank you, Judge.
All right. Okay, as soon as the copies are made, I'll come out, put those five. Okay.
Judge, we can approach.
This is a conditional guilty plea on a PTI?
Yes,
Okay.
Judge.
Wallace Craig, right up the council table?
And there's two separate accusations.
All righty.
Going to be sworn in, so keep standing, okay?
We'll go on the record and state v. Wallace Craig, appearance for the state.
Charles O'Connor on behalf of the state.
Mr. Craig?
Dolores Mann for Mr. Craig, Your Honor.
All right, we'll administer the oath to Mr. Craig.
Push left hand on the Bible, raise your right. Do you swear in the presence of Almighty God, testifying God, the case of the court in this matter to be the truth, the whole truth, and nothing but the truth? Yes. Please state your name, spell your last name for the record. Wallace Craig.
K-R-A-K-E.
All right, now, this is a proposed admission into the PTI program, but on a conditional guilty plea. I'll ask you to take Mr. Craig through the waivers and plea form, and then the terms of the PTI order.
Yes, sir. Mr. Craig, I have before me, and you have a copy as well, of two waivers of indictment and trial by jury. And did you sign these two documents today?
Yes, I did.
And they are both relative to two separate accusations, 10101-0010 and, 107, and 01-01-00108. You understand that?
Yes.
And in these waivers of indictment, what you've done is you've told the prosecutor that you don't want this case to be brought before the grand jury and have an indictment and a trial by jury. Is that correct?
Yes.
And instead you choose to plead guilty today by way of an accusation on both of these charges. Is that correct?
Yes.
And you understand that by doing that, you're giving up your right to have a trial, your right to have the prosecutor present the case to a jury. You'd have the right to cross-examine any witnesses, and you would also, you're also giving up your right to remain silent. You understand that? And you also understand that this waiver of indictment on both of these cases is the result of a plea agreement that's been entered into between you and the prosecutor. Is that right?
Yes.
And that plea is to one count, charging count 2 on accusation 107 for conspiracy to commit theft in the third degree, and also on accusation 108, the second count for fraudulent use of a credit card, also a third-degree offense.
Yes.
You understand that both of those offenses carry an exposure of up to 5 years in state prison, $7,500 fine, and there is also a Violent Crimes Compensation Board penalty of $50 on each. You understand that?
Yes.
There will also be a $75 Safe Neighborhood Services Fund assessment on each of those counts as well.
Okay.
For both, there will be one law enforcement officer training and equipment fund penalty. You understand that?
Yes.
And if you were ultimately to be placed on probation because you would terminate PTI, you understand that you could receive up to $25 per month as a charge for being on probation.
Yes.
And each time you make a payment, there's a $1 transaction fee. Is that right? You understand
Yes.
that? You are currently on probation at this time, but prior, when these offenses were committed, you were not on probation at that time. Is that correct?
Yes.
You also understand there are a number of charges that will be dismissed as a result of this plea as well.
Yes, I am.
You also understand that if the judge puts you into PTI, if you are in PTI and you are terminated for any reason, then you would come back to court on this plea agreement, where the court would then sentence you to probation along with 45 days in the Morris County Jail. And that the prosecutor is indicating that they will not agree to any slap in lieu of that Morris County Jail sentence. You understand that?
Yes.
All right. You also know there is a possibility of restitution, but I think everything was returned. But that will be determined by a pre-sentence report if that's needed. You understand that? Okay. Have I forced you or threatened you in any
No.
way? Has anybody promised you anything that's not on this plea form?
No.
All right, and you also understand that a pre-sentence report would have been done also if need be, and that the judge would have the right to reject this if he thought that it was too lenient?
Yes.
All right. However, you are going to be entering into PTI today. Is that right?
Yes.
And you have before you an order of postponement pursuant to the rule that allows you into PTI. There are a number of conditions that you'd have to complete. You understand that?
Yes.
One of which is the payment of some fines, the $75 application fee, a $75 Safe Neighborhood Services Fund, and the $50 Violent Crimes Compensation Board penalty. You understand that?
Yes.
You would also be on PTI for a period of 24 months. Correct?
Yes.
You will also have to take a tour of the jail. Is that right?
Yes.
You also understand that there are a number of penalties that would have to be paid here, and you'd pay at least $10 per month. Is that right?
Yes.
And also, there would be restitution in the amount of $4,552.33 to the victim.
Yes.
Is that right? Now, because you are currently receiving Social Security disability payments, that money would be worked out through probation, perhaps through a consent order. You understand that also? And in addition, any transaction fees by these payments would also have to be made. Is that right?
Yes.
And you're asking the court to admit you into PTI today?
Yes.
There's also $874 to American Express.
That's part of the restitution, $874 to American Express.
Thank you. You understand that,
Yes.
too?
Just to establish the factual basis, if you would, for the conditional plea.
Yes, sir. All right, Mr. Craig, on the conspiracy to commit theft on accusation 107, that second count, I'll just put it out in front of you, all right? That alleges that on May the 29th, in the township of Pequannock, right, in Morris County, that you did commit a conspiracy to commit theft with one Colleen Bishop.
Yes.
What did you do?
What did I do?
Yeah, what did you agree to do with her?
Use a car under someone else's name, or... Watch, that's what it was.
And was that done?
Yes, it was.
Did you receive anything by using that card?
Yes.
What was
Used
received?
A car.
Okay. Okay with that? All right, now, looking also at count 2 of the other accusation, indicates that in the town of Booton, on May the 10th of the year 2000, all right, did you also use a credit card as well?
Yes.
And was, what kind of credit card did you use?
American Express.
And was it your credit card?
No.
Whose was it?
Matthew Bishop.
And did you have permission to use it?
No.
What did you get in exchange for using that card?
Things over the internet.
To satisfy the factual basis, Judge, as to both accusations.
All right, court, having heard Mr. Craig's statements, is satisfied that he knows he's pled guilty to a conspiracy to commit theft and fraudulent use of credit card charges, third-degree offenses which carry incarceration exposure up to 5 years. But he knows by his plea that this is a conditional guilty plea, that he will be admitted into the PTI program under the conditions set forth on the record, and that if he is terminated from the PTI program for noncompliance, then having pled guilty, he'd proceed directly to sentencing with the recommendation of probation and up to 45 days in the jail. in that regard. He's had the benefit of counsel, and I find he's made his statements voluntarily. They're not the product of any extraneous factors or promises, other than those set forth on the record and in the plea form, and I accept the plea as voluntarily made. I admit you into the PTI program. I've signed the order of postponement. I want you to take a copy of this order over to probation right now, second floor, next building over, administration building, to be processed, okay? Go over there right now with a copy of the order to be processed. All right, thank you.
You're going to wait for the order
All right.
signed by the
I'm
judge.
with Russian interpreter.
Receipt back at your house, and that's your copy.
Okay, we have another ready matter?
Judge, I think we have,
I have three ready matters.
and I have another one. Okay.
Jesse Hilbig is in the back, Your Honor. He's been raided from Somerset. Can we do him next? So he can go
Sure.
back?
Is that a plea?
Yes,
sir.
Judge. Paperwork's up.
Okay, Jesse Hilbig? Well, what's holding him in Somerset? Because this is a non-custodial probation sentence.
Pending burglary charge.
New charge.
So what are we doing with this?
We're hoping that Somerset is going to run concurrent to this. He has no prior record.
We were going to offer PTI until this.
Well, you understand I can't simultaneously sentence him.
No, I'm not asking you to do that, Judge.
Judge, if he gets sentenced there first. Back.
Or it runs concurrent.
You believe he's going to get a probation sentence in Somerset? Just remain standing for 1 minute, Mr. Helbig. We're going to go on the record in State v. Helbig, appearance for the state,
Charles O'Connell?
and for Mr. Helbig.
Dolores Mann, Your Honor.
All right, we'll administer the oath to Mr. Hilbig. You can just administer the oath to him.
Did you swear in the presence of Almighty God?
What's the order?
Yes, please state your name, spell your last name for the record.
Jesse Hilbig, Huelbig.
All right, you can have a seat, sir. You may proceed. The waiver and plea form?
Yes, sir. All right, Mr. Helbig, you have in front of you a waiver of indictment and trial by jury. Did you sign that this morning?
Yes, I did.
You understand that by signing that, you're giving up your right to have the prosecutor present these matters to the grand jury and thereby get an indictment as well as a trial by jury, where you will also be giving up any rights you would have had, the right to remain silent, the right to cross-examine any witnesses against you produced by the state, as well as having the jury decide whether you're guilty or innocent. You understand that?
Yes.
And that's what you choose to do today?
Yes.
And you choose to plead guilty to two separate charges. One is a theft, which is a theft of a van, and also possession of a controlled dangerous substance, which was heroin. Is that
Yes.
correct?
Yes.
And they are both third-degree offenses, which means that they carry an exposure of up to 5 years in state prison. On the theft charge, there could have been a $7,500 fine, and on the possession of CDS, $35,000 fine. And there are some mandatory court assessments that the judge must impose, one of which is a Violent Crimes Compensation Board penalty for each, a $75 Safe Neighborhood Services Fund for each. There will also be a $30 law enforcement training fund for both charges. If you are placed on probation and the judge accepts this plea, you could receive up to $25 per month as a charge for probation, and each time you make a payment to probation, there could be a $1 transaction fee. You understand that?
Yes.
All right. In addition, on each of these, for the drug offense, you understand you would have to lose your driver's license for up to 6 months, could be up to 24.
Yes.
There's a mandatory laboratory fee of $50 and a $1,000, what's called a demand reduction penalty for the possession.
Yes.
All right. In addition, for the theft charge, there is also a separate form which indicates that for the theft of the van, you would lose your license for 1 year, as well as a $500 penalty because this would be your first offense.
Yes.
All right. You understand all that?
Yes.
And you choose to plead guilty to both these offenses today?
Yes.
All right. Have I forced you or threatened you in any way to enter this plea?
No.
Has anybody promised you anything other than what's written on this form?
No.
You understand that the prosecutor has agreed to recommend to the court that you would receive a non-custodial probationary charge?
Yes.
Okay. Now, you also understand that if there is any damage done to the van, then restitution would have to be paid by you. You
Yes.
understand that? Are you satisfied with my services?
Yes.
Okay. All right, now, turning your attention to February the 12th in Morristown, did you take a van?
February 12th?
February 12th in the year 2000?
No,
Wasn't February the 12th?
no.
What date was it, Mr. Helvig?
December 1st.
You can continue, and we'll check the date.
All right, Judge. All right, also, was it on that same date that you also had possession of heroin?
Mm-hmm.
Did you know it was heroin?
Yes.
Where did you have it?
In my jacket pocket.
Okay. Was that also on December the 12th?
Did you, maybe I could, did you take the van on December 1st but were caught with it on February 12th?
No. It says 2000, I was caught December 2nd.
I think what happened on the complaints is it shows the day as being the 2nd and the month as being the 12th, and it was probably reversed. So I think it was reversed on the complaint, and it should have been December 2.
Correct, Judge, because I'm looking at the commitment, and his commitment was 12/3. So,
Can we
We'll
correct that?
amend the accusation to show that it should be December 12th rather than the February 12th date. It should be December 2nd, excuse me, rather than the February 12th date. And we'll change that on the accusation. And the accusation is so amended.
Thank you, Your Honor.
Judge.
All right, anything else on the factual basis?
State satisfied, Your Honor.
Court, having heard Mr. Helbig's statements, is satisfied that he understands he's pled guilty to theft and possession of heroin, that this was theft of an auto, as well as possession of heroin. He knows these are third-degree offenses which carry incarceration exposure up to 5 years, but he understands by his plea that the recommendation here is non-custodial probation with mandatory fines and penalties on the auto, mandatory $500 fine, 1-year loss of license on the possession of heroin, $1,000 drug enforcement, $50 laugh fee, minimum 6-month loss of license. He's had the benefit of counsel. I find he's made his statements voluntarily. They're not the product of any extraneous factors or promises other than as set forth on the record and in the plea form. In that regard, it's my understanding that he is pending burglary charges in Somerset County, but there's some indication that he may be placed on probation as a result of those charges.
Yes, sir.
Accordingly, I accept the plea is voluntarily made. In terms of sentencing here, April 6th, is that, will Somerset be resolved by then? What's your status in Somerset?
I'm not too sure of when my court date is for them.
I'll set it for April 6th, and we'll need them written for that day, okay? You'll be interviewed in Somerset for your pre-sentence report, okay?
Thank you, Your Honor.
All right. Thank you.
Judge, on the 3-defendant Russian interpreter case, the interpreter said that he brought them down. They applied for PTI, but they're going to be evaluated, so we're wondering if we could have perhaps 2 weeks now.
Okay, we'll schedule those EDCs for February, the EDCs for February 6th, okay? Could you explain to them that we need them back on February 6th, and that we'll need the Russian interpreter that day? And this is on Boris Busenzi, will be 2-6. Leah Davitsvili, February 6th. Vasila Malinsky, is it?
No, Malinsky is the other case,
Oh,
Judge.
okay.
Zurab.
Zurab Rekadze will be February 6th, and what's the other one?
That's it.
That's it.
Just those three?
Yes.
Okay. Those three individuals need to be back here February 6th, 9 a.m. All right? We'll see you then. Boris B, with the B.
Right.
Leah Davitsvili.
Okay, that's the one I was.
All right.
Thanks.
Okay.
Pequannock.
How do you say it again?
Quonic.
Quonic.
That's okay.
It's a tough one, it's a tough one.
Unless you're from Mars, you wouldn't know that.
Even you're from.
I know that, I'm from
Mars, you
Essex,
wouldn't
Jay.
This is Pequannock, yes. But we've said it as Pequannock many times. Okay, we have another ready matter?
Two more, Judge.
All right,
know. Three more.
Three more.
okay. Are these PTIs, please?
Yes, they're all PTIs, Judge.
Okay,
I'm sorry.
let's take all three PTIs, then we'll start. What's the first one?
Danielle Nemeth.
Danielle Nemeth, come right up here.
I know, I'm coming with
George.
If I may.
It's for you, George.
It's your copy, sir. You're going to be sworn in, so.
This is State v. Nemeth, appearance for the
George
state,
Dave, you're on behalf of the state.
and for Ms. Nemeth.
Dolores Mann for Ms. Nemeth.
All right, you may proceed.
Ms. Nemeth, you can have a seat. All right, Ms. Nemeth, in front of you is an order of postponement. It's an admission into, order admitting you into PTI. And have we gone over this order and you've signed it today?
Yes.
All right, and also attached to that is a waiver of indictment and trial by jury. Have you also signed that document?
Yes.
And you're also, by signing this document, you're telling the prosecutor not to indict you because you're choosing not to be tried by a jury on this charge. Is that right?
Yes.
All right, now the order of PTI, the court accepts it, requires you to go into PTI for 3 months, 3 years, is that right?
Yes.
And you understand that you'll have to make some payments, a $50 Violent Crimes Compensation Board penalty, a $75 Safe Neighborhood Services, and also a $75 application fee. You understand that?
Yes.
You also have to do 50 hours of community service.
Yes.
And anytime you make a payment to PTI, they'll impose a transaction fee as well. Right? There will also be a jail tour. You will have to go through the jail, right? You understand that? And you agree that you will pay to PTI at least $75 per month towards the application fee, as well as the restitution that will be given to the victim, Donald Canfield. Is that right?
Yes.
And that restitution is in the amount of $1,705. Is that right?
Yes.
And you do not dispute that amount?
No.
All right. And you asked the court to be admitted into PTI today?
Now, Ms. Nemeth, I know Ms. Mann explained to you that this is a one-time opportunity. You took advantage of PTI now. If you were the subject of new charges, would not be available to you again. You understand that?
Yes.
As long as you comply with these conditions, at the end of your supervision period, this matter will be marked adjusted, administratively dismissed. If you fail to comply, you'll be terminated from PTI. The matter will be restored to the trial list. You'd have to go to trial on this charge unless you pled guilty. Do you understand that? Okay. We've signed the order. I want you to take a copy of the order over to probation right now, second floor of the administration building, next building over. Go to the probation department, take a copy of the order with you to be processed, all right?
Okay.
Good luck to you.
You take that with
Go
you.
right over to probation.
Okay.
Okay, next matter.
Mr. Malinsky?
Mr. Malinsky? This is State v. Malinsky, appearances.
George Dave, you're on behalf of the state.
Dolores Mann on behalf of Mr. Malinsky, Your Honor.
All right, this is a proposed admission into PTI. You may proceed.
Thank you, Judge. Mr. Malinsky, in front of you, you have a waiver of indictment and trial by jury. You signed that document this morning?
Yes, I did.
You know that by signing that document, you're telling the prosecutor that you don't need this case indicted, and you're not seeking a trial by jury, instead you choose to be admitted into PTI today?
Yes.
And that's on the underlying accusation, is that correct?
Yes.
And you've read that underlying accusation?
Yes, I did.
Okay. Now, the order of postponement has certain conditions in it, and you agree to all of those conditions, is that right?
Yes.
You will be, if the judge admits you, you will be in PTI for 18 months. You will be required to pay certain penalties, a $50 Violent Crimes Compensation Board penalty, $75 application fee, and $75 Safe Neighborhood Services Fund. Do you understand that?
Yes.
Understand you'll have to take a tour of the jail? And you will also have to perform 50 hours of community service?
Yes.
And you know that you will also have to pay a transaction fee each time you make a payment to probation for PTI?
Yes.
And you will make these payments by at least paying $20 per month, is that right?
Yes.
And you're asking this court to accept you into PTI today?
Yes, I am.
Mr. Malinsky, you know this is a one-time opportunity. You took advantage of it now. If you're the subject of new charges in this state or New York or any other state, PTI won't be available to you again, most likely. You understand that? Now, as long as you comply with all these conditions, this matter will be marked administratively dismissed. If you do not, it'll be restored to the trial list. You'll have to go to trial on these charges. Just as I explained to the other individual earlier, you're living in Brooklyn, New York. By the way, the order should be changed to New York instead of New Jersey.
Okay, Jeff.
Okay? Which means you've got to take responsibility to make sure your community service, jail tour, your fines, everything's done here, okay? You can't just sit back and say, I didn't hear from anybody. You're going to go over to probation right now with a copy of the order, second floor, next building over to be processed, and they'll tell you how you'll be supervised in Brooklyn, okay? All right, good luck to you.
Signed order, but this is your card.
Okay, we have one more matter?
Yes, Judge.
Name?
Thomas Sear?
Right. and
Judge, we don't represent him, he didn't qualify.
Okay.
I told him I didn't represent him either, Judge, but
All right,
PTO
have
was
him.
available. Is it sincere?
This is State v. Cecere, appearance for the state.
Dave, you're on behalf of the state?
Okay, and you are Thomas Cecere.
Yes.
Now, stay standing, Mr. Cecere. Mr. Cecere, you understand that you had the right to an attorney in this matter.
Yes,
But you've decided to waive that right and proceed to represent yourself?
yes,
And you're doing so voluntarily?
yes.
All right. And you understand that you may have spoken to the prosecutor about the offer here or about the case, but the prosecutor represents the state of New Jersey. He does not represent you. Do you understand that?
Yes.
Okay. And knowing that, you're willing to go forward representing yourself and you're requesting that the court enter you into the PTI program. Is that correct?
Yes,
And in that regard, you signed a waiver of indictment, which means you waived your right to have this matter presented to the Morris County Grand Jury for that body to determine whether there's probable cause for you to stand trial on this charge. You're waiving that, and you've agreed it can proceed by way of an accusation, what we call a complaint to the prosecutor, an accusation, setting forth the charges here of uttering a forged instrument and theft. Is that correct?
yes.
I'm going to accept the waiver as voluntarily made, and I'm going to enter a not guilty plea for you on the charges, and I'm going to admit you into the PTI program, which calls for the following: 3 years of probation.